Barron said, my name is David Goldman. I work for Frank Pallone, who's the top Democrat for the Energy and Commerce Committee over in the House. If you know Congressman Pallone, you probably heard him explain why he came to Congress in the first place. He always says he's here to fight for the little guy. And in the case of communications and technology, that usually means consumers. So he tells us he always wants to make sure that our policies put consumers first. And that's why he's such a staunch defender of our personal privacy in all areas, because at least when it comes to the internet, privacy may be the one thing where nearly all consumers agree. According to recent government data, 84% of Americans are worried about their privacy and security online. That finding follows a comprehensive report from Pew Research earlier this year showing that 91% of adults believe they have lost control of how companies collect and use their personal information. That explains why nearly 3/4 of internet users want to have a say over who can get their information. But the truth is, privacy concerns go beyond just consumer welfare. People's fears are having real consequences on our economy too. More than half of the households that are worried about their privacy say that they avoided online economic and civic activities because of it. So that can have a real impact on our economy. Fortunately, the data also points us to a solution. Nearly 7 in 10 consumers believe current laws do not do enough. Americans are clear on what they want government to do. They want their government to give them more control over their information. This kind of consensus on how to improve the economy and protect consumers does not come often. When it does, Congressman Pallone believes that the government's job is to listen. So he's grateful that the FCC has proposed more privacy protections for consumers online. But once the FCC announced it was considering new rules, the rebuke from critics was swift. They condemned the effort. Their argument was essentially that strong privacy rules that applied only to ISPs would create so much consumer confusion that the rules would be more harmful than doing nothing at all. This argument itself can be a little confusing because it depends on some arcane relics of agency authority and procedural rules. So forgive me a quick walk through some agency law, so sorry about that. So the FCC, which regulates internet service providers, has power to instill before the fact rules of the road to protect your privacy. The Federal Trade Commission, on the other hand, oversees websites, and they have limited ability to make new rules. Instead, the FTC relies on after-the-fact prosecution of companies that breach their own privacy policies. And we must now actually add to the mix a recent court decision out of the Ninth Circuit that has thrown the legal landscape into chaos, potentially undermining the FTC's already limited ability to protect consumers without the FCC's help. So this current situation is not great. Nearly half of the internet users in the Pew survey said they are already confused, discouraged, and impatient with the privacy landscape online. No, sorry. They're frustrated by the maze of ever-changing company privacy policies. That's why Congressman Pallone agrees with those that say consumers should be protected by strong privacy rules from any company that can collect and monetize their data, whether it's a website or their cable company or internet service provider. But he does not agree that means that the FCC must restrict its own actions to match the limits on the FTC. Just the cost to our economy would be too high. Instead, the optimal result would be for both agencies to adopt strong, harmonized consumer protections. Unfortunately, the current restrictions on the FTC prevent this from happening. Consumers are right now left vulnerable. Luckily, once again, the American public has shown Washington the way forward. In the face of the current uncertainty that they're feeling, the vast majority of internet users, 64%, would prefer the government do more to protect personal information from companies. The facts are plain. Consumers want more protection, not less, to ease their confusion. Congressman Pallone therefore believes that the FCC should listen to the American people. It should move forward with strong privacy rules. And these rules should deal with something called pay for privacy. If you're not familiar with these kind of arrangements, they occur when a company tells consumers to pay extra to protect their personal information when they come to those companies. For Congressman Pallone, strong rules mean that all consumers can afford to protect their personal information and keep their information private. No one, no matter their income, should be forced to choose between privacy and staying connected. And here too, what is good for consumers can also be good for business. Just look at AT&T, not talking about the merger, which recently experimented with a version of this kind of scheme earlier this year. After trying it for a few months, AT&T announced that they were ending that program. They rightfully found it was better just to offer one plan for everyone. And they actually, when they went across and did that, they put everyone at the lower cost. So it wasn't necessarily that they went through and said, now everyone has to pay more. But to achieve the truly optimal approach, Congress must step up and fully empower the FTC to protect consumers too. In one fell swoop, Congress can answer the public's call, maximize the economic power of the internet, and resolve the critics' concerns about mismatched privacy rules. Congress can simply lift the out-of-date restrictions on the FTC. If Congress gives the FTC the ability to adopt new rules, we can achieve strong consumer protections that make sure our privacy is protected, no matter where we go on the internet or how we connect. But while powerful protections from both the FCC and the FTC may seem obvious to most Americans, some here in Congress have chosen to go the other way on privacy. And in fact, an effort is currently underway to actually gut the FTC of its existing authorities. These proposals blatantly run counter to the public interest, and they should be abandoned. Congressman Pallone believes that both the FCC and FTC should adopt strong new rules. Together, we can deliver for consumers and maximize the power of the internet. So that's all I got. I hope Barron found at least one thing he agreed with in there, but I'm skeptical. No, right. So thank you. Appreciate it.
Okay, as Barron said earlier, I'm Maggie Reardon. I'm a reporter with CNET, an online tech publication, and I've been covering policy in the FCC for a lot of years. So I'm going to have each of our panelists here introduce themselves very quickly, and then we're going to just launch right into questions. So let's start on the end. Tim, if you want to give us a quick introduction.
Sure. Hi, my name is Tim Sparapani. I'm here with CALinnovates, one of my clients. We're happy to welcome you all here for what is a really important conversation, and one that I'm not sure that we've gotten right just yet. I've been doing this sort of stuff for a long time in a variety of settings, and I'm happy to be here with my fellow panelists.
Okay.
Thanks. This one. I'm James Cooper. I'm at George Mason Law School's, George Mason's Antonin Scalia Law School, newly renamed.
Renamed.
What?
Renamed. Yeah.
Thank you. We like to forget about that. Those 10 minutes of infamy. I'm also the director of the program in economics and privacy, which is also at the law school, where we focus on injecting, as the name suggests, injecting economic analysis into privacy policy debates.
So my name is Mark Rodenberg. I'm president of the Electronic Privacy Information Center, EPIC. I teach privacy and open government at Georgetown Law School. I've been working on privacy issues with the FCC since the days when telephones had rotary dials. Now, if you guys don't know what that is, you'll see them in the movies sometimes. It kind of goes click, 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 click as it turns around. But I also wanted to thank Barron for putting the event together, for inviting us, and pointing out that we don't always disagree. In fact, we have a joint petition with EPIC, TechFreedom, and about 30 other organizations to the FCC asking the agency to end the mandatory retention of customer data by the telephone companies.
Okay.
And I'm Kristen McMaley. I'm a partner with the law firm of Davis Wright Tremaine. I too have been operating in this space for some time. I've worked with communication companies in one way or another since 1990. A long time, 1996. And interesting, that was the year that the FCC first had jurisdiction with the CP&I rules. They went into effect in 1996. But before that, there were privacy provisions in the Communications Act that applied to cable providers. So we've been working with those provisions and with companies and helping them understand and comply with those provisions. Since then, I also was in-house counsel, chief privacy officer for a broadband and cable provider, so I see it from both perspectives.
Okay.
And I'm Baron Soka of TechFreedom. I've been working on these issues since about 2008, both on the Federal Communications and Federal Trade Commissions. We're one of the few organizations out there that works on both agencies, and so I have things to say in response to David about both.
All right. Well, let's just get to it. Kristen, I'm going to start with you. David gave us some background, but can you sort of fill in some of the gaps on how we got here? How did the FCC get to this moment? And just to sort of refresh everybody's memory, this is a vote that's happening on Thursday, right?
Right, it is. So looking back and why we're here and why the FCC is doing what it's doing today, and for this first part, I'm going to be I'll try to be very factual so that it gives everybody a basis for then responding. But in 2015, the FCC reclassified broadband internet access service as a Title II common carrier service, which means now as a common carrier, it is not subject in one way or another to the Federal Trade Commission's authority under Section 5. And so the FCC found that given this gap, they needed to create some privacy rules to address the activities of broadband internet access service providers, which I'm just going to call ISPs. That'll be my term. You guys can call them whatever you want. So they're going to create rules for ISPs, and they held some workshops throughout 2015, and then I think it was in April of 2016, they launched the rulemaking that, as we mentioned, there is going to be a vote on Thursday. And they initially, when the NPRM came out, there were some draft rules, and the way that the commission framed this was they set it up as a use-based framework for broadband providers, meaning most of the information, similar to the old telephone rules, most of the information collected and used by ISPs would be subject to a customer's opt-in consent for them to use it in most ways, with some very limited exceptions. As soon as the rulemaking, the text came out and comments started coming in, there were a lot of comments filed on all sides, including some comments by the FTC saying that this was not consistent with the privacy framework that they had set up in the 2012 FTC privacy report that has been clarified and used as a basis for their enforcement actions in the years since. Again, after a lot of meetings, reviewing all of the comments, earlier this month, the FTC issued a fact sheet and a notice saying that Chairman Wheeler had revised the initially proposed rules and moved to a sensitivity-based framework and circulated this proposal among the commissioners that would be subject to the vote on Thursday. So just very briefly to set the stage about what was in that proposal. First of all, the scope of the proposal. The chairman has said on a number of occasions that the proposed rules only apply to ISPs in their role as a broadband internet access service provider. It does not apply to them to the extent that they have other businesses. It doesn't apply to other businesses on the internet, like edge providers, and it doesn't apply to the websites of the ISPs. The other thing that, then starting with some of the substantive rules, once we get past the scope, clear notification is one of the hallmarks of the FTC's regime, and similarly the FCC talks about notification to consumers, like the privacy notices that we see. So when a customer signs up for service, they will get a privacy notice. That notice will be available on the website, and the ISP is going to be required to update the notice, update customers when there are significant changes to that notice. The one thing we were just talking about how concerned or how confused we are as consumers when we go on the internet, looking at all of the privacy notices, the FCC has said it's going to create a multi-stakeholder process to come up with a standardized format. Now again, this is only going to be for ISPs, not for every other entity on the web, but ISPs will have this standard format. The change from the use-based model that I talked about initially and that was initially in the proposed rules now is an opt-in, it contains opt-in consent for sensitive information. And sensitive information, this is really, I think, where a lot of discussion is going to be held today. It includes the types of information that the FTC has historically categorized as sensitive, so children's information, health information, financial information, social security numbers, and the FCC has also included geolocation, but just to be clear, they didn't say precise geolocation. The FCC also included as sensitive content of communications. That was based on the FTC's recommendation in its filing. And in addition, it added web browsing history and app usage history, which I think is where some of the discussions will be. What does that mean, and does this really now make this a sensitivity-based framework? Additionally, it made all of the other use and sharing of non-sensitive information subject to opt-out consent, including uses of information, of non-sensitive information for first-party marketing. It did follow the FTC's test for de-identification, so you could de-identify the data and then share it. And it would also, the financial incentives that we heard about from our keynote speaker would be permitted, but they would be subject to heightened notice, and they would be subject to a case-by-case review by the FCC. Okay. And then, of course, there's the information security requirements, which appear to be relatively standard, and then breach notification.
So in short here, from the way I understood it and from what you described, initially the proposal for the FCC, they were requiring an opt-in pretty much for all information. If it's going to be shared with a third party, consumers have to opt in.
Also used internally.
And internally, okay. So then they revised that in this latest proposal, and they said, they'll follow what the FTC does, and it will only be opt-in for sensitive information. But I think the discussion that we're probably going to have here, and what people seem to still be kind of confused about, is what is considered sensitive information and what is not sensitive. And that the FTC defines it one way, and the FCC, it looks like, is defining it another. Is that sort of the crux of what most of the argument is here, or am I making it too simple?
I think you're probably right. And
Okay.
though you should make it sound more complex so we all sound smarter.
Right.
Maggie, but
Right.
before we get into that debate,
Right.
let me just say there is also a big process concern here. I mean, this has become a pattern at the FCC where the agency puts out a proposal, gets a lot of negative feedback about it, and then says, oh, yeah, we hear you. Here's a new fact sheet about how we're going to revise this. And then they change what they end up doing. So right now, we're in this awkward position where we're talking about something that none of us have actually seen. It's significantly changed, apparently, from the initial proposal, but we don't know exactly what's in it. All we have to go on is this fact sheet by which the chairman's office makes broad assertions that what they're doing will now be consistent with the FTC approach. And I just want to raise that.
Which I've just about read, right? So you've gone from a how many hundreds of pages in the rulemaking, the text of the rulemaking that came out, to now the arguments are based on a few
And the
pages.
point here is that I know most people, how about this? Raise your hands if you care about administrative law, right? Okay, so, well, wow. That's almost half the people in the room. Well, it's not a representative sample, I'm sure, right, of the American people, although I'm sure the Trump nation cares deeply about administrative law details. But it matters, right? It matters because if you, for example, if you get into the habit of revising significantly your proposal and then putting out a fact sheet and then voting on it and revising it at the last minute or continuing to edit it the day that it's voted on, which is something that not just this chairman but past Republican chairmen have done, you deny the public an opportunity to comment on what's being done. So I just want to say, before we get into details here, I suspect we probably would all agree, independent of anything else that we discussed today, that it would be better in this case and other cases if the agency did what administrative law, in my opinion, requires, which is you put out a further notice of proposed rulemaking where you revise your proposal, you explain why you've revised it and what it means, and then you can have informed comment on it. And this chairman simply doesn't want to do that. He's never done it for a single proposal that he's initiated.
Right. And I know that that's a big concern of yours, and we're not talking about administrative law here,
Right.
but and from my understanding, the other argument would be that isn't always the case. You have to determine if this is a significant change or not, or if it's a minor change, right? Like proposals change all the time as they're, right? So I think that's sort of the debate that you could have on a different panel. Maybe we'll do that next week. No, I'm just kidding.
But the narrow point is simply that we're operating in ignorance. So when we discuss this today, we are to some degree, we are speculating about some aspects of this. Now, we know some of this, but we're really not sure about other parts of it, and we may be surprised. And so it's just important to note that it's not as if we actually know all the details. We're having this discussion today, in part, you might ask, well, why didn't we wait until after the thing was voted on? Well, in part, that's because when the order is voted on Thursday, assuming it even happens, and it could fall apart, the chairman just revoked something at the last meeting, but assuming that the vote does happen, it'll still be weeks or even months before that issue comes out. So it's not even that we'll know once the thing is voted on. When it's voted on, maybe the commissioners will be free to talk about it more, but we're still going to be in the dark about this, and that's just not a good way to make law.
Okay, all right. Well, before we get into everything, I just want to correct one thing. The hashtag on Twitter is FCC privacy, right? So not FCC Live. So if anybody's looking on Twitter and wants to join us for the discussion, that's where you should do. Okay. And let me go to Mark real quick here, because, I think from your perspective, you guys aren't really satisfied with what the FTC is doing anyway. So, and I think that's something that David sort of alluded to as well, that system isn't really working so well.
Right. So let me say, I think we agree with people's intuition that it would be nice to have harmonized rules, level playing field, clearer for consumers, clearer for participants. Actually drafted some legislation to do that for the internet some time ago, and that's still what we would favor. But I think the reality that we confront today doesn't make that a likely outcome. And the simple problem is this. From our perspective, the FTC approach is not working. It's not working because the agency simply refuses to enforce its orders. So when you have a determination, as we brought, by the way, cases against internet companies like Facebook and Google back in 2011, and broad settlements and consent orders, and we said, boy, this looks great for consumers and will put in place some real meaningful safeguards. When the companies changed their practices, the FTC remained silent. We actually sued the FTC and said, why don't you enforce your consent orders? Now, if you want two practical examples today of what I'm referring to, Facebook acquired WhatsApp in 2014. WhatsApp said, oh, don't worry, users. We know you like our service. We're going to keep our data private. It was a big representation. This summer, they said, well, we've kind of changed our minds. We're going to make the verified phone number, essentially the key for the WhatsApp user account, available to Facebook. We said to the FTC, it's entirely contrary to the representations that they made. Same thing, by the way, with Google and DoubleClick. So Google acquires DoubleClick, says we'll keep the user profile separate from the advertising profile. Again, the companies change their business practices. So if the FTC were willing to enforce its Section 5 orders, then we would say, gee, maybe the FCC could, follow a similar standard and we could have a harmonized approach. Again, we're not against it. But the key point here is that the FTC approach is not working, and that's the reason that we do think the FCC needs to move forward with its own regulatory framework. Now, of course, we'd like the framework to go further. We don't think this old-fashioned style, notice and choice approach to privacy protection works anymore. It's actually very 1990s. I mean, you mentioned the CP&I rules. It's a way of kind of extending the CP&I rules to broadband service providers, but it's even a bit
Before
less.
we go on,
Okay,
what does that mean, CP&I rules?
Well, basically says that a communication provider has access to certain data about the user that's generated by the communication transaction. The CP&I is literally customer proprietary network information. And so the question becomes simply this, do you need to obtain consent from your customer to use that information for marketing or to transfer to a third party? And if you do need to obtain consent, is it opt-in or opt-out? I mean, that's, typically how we talk about the CP&I rules. Epic supported that in the 1990s. We thought it was appropriate in the day. Today, we think something much more robust needs to be done. I mean, there are huge problems with government monitoring of telephone data, huge problems with data breach, and we don't think that they're adequately addressed by the proposed rule.
What about this idea, though, of, and this is something Kristen and I were talking about before this started, is as a consumer, I don't care if it's the FTC regulating, the FCC regulating. I don't care if it's regulation on my ISP or on Google, Facebook. My experience is I get creeped out when I start seeing advertising on my Facebook feed, and I'm like, how in the world are they doing that? So, I mean, is it realistic to have sort of a strict, different sets of rules? If they're not harmonized, is that realistic? And what can be done to?
Yeah, I mean, I think not only is it realistic, I think given present circumstances, the likely outcome, but you also make a very important point, Maggie, which is that the public concern about this issue really is high. It cuts across all demographic groups, all regions of the country. People are genuinely worried about what's happening to their data online. And I think the consequence, of course, is that lawmakers in Washington and the federal agencies are trying to figure out what to do. Now, people would like a nice, simple solution, and if we could find a simple solution, I think that would be preferable. But I think no solution is the least desirable.
Okay, so is your thinking here, let's just get some rules that the FCC does that maybe gets part of the market, and hopefully we'll see how those work, and maybe we can somehow figure out a way to regulate the rest of the industry?
I think that would be a step forward. I mean, to be clear, Epic at the outset did not make the distinction between the ISPs and the edge providers. We actually wanted a common set of rules for all participants in the internet ecosystem. That's what we said to the FCC, and people said to us, well, we're going to have to focus on ISPs first, and then we'll get to the edge providers. And we said, okay, maybe that's the way to go.
But I understand that the FCC doesn't have jurisdiction over the edge providers.
It's a little unclear,
Right, okay. Okay.
I've heard them say that.
Right.
I've heard some other views as well.
Okay, and Tim, I don't know if you want to jump in here, and I mean, do you think that there should be, sort of a harmonized approach, and if there should be, why isn't it okay to start with the FCC?
Sure, yeah, it's a great question. But I want to step back because I think Mark is making a really important point. We're all consumers. We all want more privacy. And looking at the rule, I'm a bit of a heretic, and I would say that we need a do-over here for the FCC. And the reason is because I think we're trading one resource-constrained agency, the FTC, for another resource-constrained agency, the FCC, right? And the net result here is that likely we're not going to get any more privacy enforcement action by trading one regulator for another. And just as you see the FCC about to stand up a set of privacy regulators, the FTC is in fact taking its resources down, and they're trading, and they're going to begin repositioning their agency resources to enforcing all the other statutes that the FTC is empowered to regulate. They have another 50-odd statutes that they're enforcing on behalf of consumers and increasing consumer protection. So I think we all probably want more cops on the beat of privacy, and the net result of this interplay between these two agencies is likely to get a zero-sum outcome or something approaching it. And in fact, there may be a period of time where the FCC does not yet have the right staff in place, the right, in terms of intellectual expertise, ready to regulate. They may not even understand yet how to begin to set forth new regulations. So we could actually feel a gap
right. I mean,
for consumers, and I think that's just one of the problems.
You feel that there's not enough money, but if you use that as the argument, then why have any regulation, right? Because no government.
Oh, well, I would never make that
right.
place. No, listen,
Yeah.
I'm all for more privacy. I will take a back seat to no one with respect to wanting more privacy. I'm just not sure that this rule, as written, is calibrated to actually do that in the sense of it actually putting more cops on the beat or coming up with better rules. And I think the other point here that we have to look into is this weird thing that's about to happen with the rule, where we have companies like AT&T buying Time Warner and Verizon buying Yahoo and owning the Huffington Post, where consumer data is going to come in at various different moments from all these different companies, and is going to be subjected to radically different privacy regimes based on how it was collected, even though it will be in the same corporate conglomerate. And nothing in this rule resolves that question. And so, to my mind, we need to step back and have a rule that's actually going to stand the test of time, and that will be based on following consumer data. Right? I think that's what we all want as consumers, right? And I think that would also, align well with what innovators need, but this rule doesn't yet do it. I bet Mark has an opinion about this, but Mark, don't we want more cops on the beat? And doesn't this end up with a zero sum?
Well, Tim, I mean, you're making a lot of good points. And as you know, one of the things to say about EPIC is we're not necessarily in favor of more regulation. I mean, if there's good technological solutions to communications privacy, like encryption, for example, we're all in favor. I think whatever you can do to minimize the burden on business is a good thing. Now, that doesn't mean that we don't care strongly about this issue. But to your point, I would say this. If we can't get, a harmonized rule between the FCC and the FTC, I think at least what the FCC could do to keep things simple for compliance issues is not to start creating lots of new categories. And for example, the distinction between sensitive and non-sensitive information, I don't think that's workable.
So Mark, but before we get into that,
I agree.
That's what a lot of this discussion is about. I just want to make sure one thing's really clear, because people may be confused about this. Even those of us who really hate the FCC and want to wind down the agency and transfer its functions to the Federal Trade Commission or the NTIA.
Tell us how you really feel, Darren, please.
Even those of us who think that will recognize that the FCC has to do something here, because reclassification, which I would not have done in the way that the FCC did, and specifically the way that the FCC did it, deprived the FTC of jurisdiction over retail service. So that was the most radical form of reclassification possible. I would not have done that. I would have left this set of issues in the hands of the FTC, even if I had reclassified other parts of the broadband process, okay? But I lost, or at least that has already happened, and the courts have yet to finish ruling on that. It's possible they will. We're appealing. This is still going to work its way up to the DC Circuit and the Supreme Court. But in the meantime, I will recognize that the FCC has created a vacuum and that the FCC has to do something. So the debate here is not about whether the FCC acts, it's about how. And my argument in a nutshell is, first of all, the FCC doesn't necessarily need to make a rule. The FCC has, like the FTC, has standards that it can apply on a case-by-case basis. So one option here, my preferred option, would probably have been that the FCC either not issue a rule, or at least that it not rush its way into issuing a rule. Because a lot of the argument now is, well, geez, consumers aren't being protected today because even though the FCC has legal authority, they haven't implemented a regulation. Well, I think that's just not accurate legally. There's nothing to stop the FCC today while this regulation is being discussed, if they were to do a further notice, for example, from going after companies on a case-by-case basis under their existing consumer protection authority. And then the question becomes, well, how should they use that? And to me, privacy is just one example. It's just one thing, along with data security, that the agency could be doing, and among other things the agency will do in the future, to protect consumers. Because Section 201 and 202 are the core of Title II, and the FCC forbore from a lot of other things in Title II, like those CP&I rules that have been mentioned today. So it said it wasn't going to apply those, but it is applying those core standards. And the fundamental question is, what do those mean? And thus far, when people have talked about harmonizing approaches, they've just focused on specific aspects of the approach. So think about, and I'll stop here, think about an equation, right? Where if you have, at the end of the day, the output of a regulatory process is, what are the particular rules? How do you treat sensitive data? Does context matter? And so on. Those kind of things either get put into a regulation or into case by case as it evolves over time. But there are lots of things on the other side of the equation that produce that. And there are things like, what's your legal standard? Do you look to balance harms with benefits, as the Federal Trade Commission does, or do you just assert that you can do whatever is in the public interest, and you multiply that by what's your enforcement approach? And one thing that's worth noting here is that, as concerned as I am about how the FTC works, for different reasons than Mark, basically that the agency gets to wield its power through case by case without ever going to court, and thus gets away with things that I don't think it actually should get away with. And in that sense, I'm concerned about how the FTC works. That problem is actually likely to be much worse at the FCC. And so what we're likely to see going forward is that the agency has really far more discretion, even if it puts stuff into regulation, it's going to have far more discretion because it's effectively going to operate case by case. It's going to force companies to settle, as it just did with T-Mobile, for example, because the agency has a lot more power and companies have a lot more to lose in dealing with this regulator. So I just want to make sure that as we talk about this, before we get into the specifics of what should the FCC's privacy regulation look like, we keep in mind that this is just, it's the big picture of a broader battle about consumer protection under the FCC going forward, which has really, really broad powers.
Okay, all right, Kristen.
Yeah, and I just want to add just a little bit to the statements that have been made. I mean, you mentioned that the FCC doesn't need these regulations that they can enforce, and they have already. Never before had they talked about customer proprietary information, which is different than customer proprietary network information, but that was enforced for the very first time in November of 2014, thank you. And so the Euratel Telecom enforcement action, where they were regulating things like social security numbers, not the information that was flowing across the telephone wires, which is what they had always regulated in the past. So to say that they have to create these rules just isn't true. And even to look at what the CP&I rules are, they were part of, as I mentioned before, the 1996 Act, which was to promote competition. So it's a very different environment, and you had incumbent telephone providers using customer information to market for themselves as a barrier for new entrants. So it's a little bit of a different context, but even if the FCC is going to take the statute that was not intended to do what they're doing with it, even if they are going to create rules under Section 222, what I haven't heard that the FTC rules don't work. I did hear, Mark, you say that you would like for them to go further, but a lot of the complaints are that they're not enforcing them. So at a minimum, for consumer, to meet consumer expectations and to have a harmonized experience, if we start with that as the base and then let Congress do its job and move us wherever we need in a harmonized way, I think then the FCC can enforce, and we have that framework that exists and is applicable to all entities across the internet ecosystem.
Well, let's get a little bit into some of the details. And as we sort of have alluded to here, this idea of, sensitive information versus non-sensitive information, that distinction. James, I don't know if you want to jump in here, if you think that that's,
Well, I guess what maybe I'll go back a little. I think
Okay.
there's a lot of back and forth.
Okay.
And I'm not as aggressive as Barron, so I wasn't able to sort of. I'm a guest here, so to jump in. But I would say that hearing Tim and Mark talk. I mean, maybe it sounds like they're kind of glass half empty guys. I'm more of a glass half full guy when it comes to consumers. I mean, this idea that, there's surveys and we think we need more regulation. Consumers feel like they're out of control. My biggest concern about where the FCC is going with this, and it's also a concern that I share along with Barron as far as where the FTC has been, is it's sort of lack of evidence of harm. I'm an economist. I have this center that's about economics and privacy, and I think that's one of the problems here is that privacy as a regulatory endeavor has really grown in importance. Data is sort of, to use a horrible cliche, data is the blood of the innovative economy. But if you compare the level of analysis and where we get our notion of consumer harm and where this idea of a market failure, which I think is a necessary condition for any sort of regulatory intervention, it's not grounded in good evidence. It's not really evidence based. I mean, in the sense that if you look at for instance the way two things, the empirical evidence that's out there. There are lots of studies. They tend to suggest, in fact, not tend to, I think without a doubt, they all suggest that people are willing to. The willingness to pay or willingness to accept for their data is teeny, tiny, okay?
although, David did sort of talk about some of those studies about.
Well, no, those
people
aren't
are less-
studies, those are surveys. I mean, it's a huge, huge difference. I mean, again, I don't want to get in the weeds, but there's a huge difference in economics between what's called revealed preference and stated preference. And I can give a survey and say, how many of you think are out of control, data's out of control? Well, everyone here raises their hand. I mean, the fact that people want more privacy, all that means is that privacy is what we call as economics a normal good.
Right.
Means that if the price goes down, I want more of it, right? I want more, basically anything in this room and anything out there. I mean, I want more of if the price goes down, or if I become richer, I want more of, right? But I also make trade-offs all the time. And so if we look both in the empirical lit at the trade-offs people make, people are willing to trade data for minuscule amounts of money. And these are, you know, the no matter, you know, again, there's a stack. And then the other thing, if you just kind of look in the real world, look at revealed preference we see in the real world, right? We see 1.2 billion people, you know, I don't need to go through the stats, but I mean, half the families have Amazon Prime accounts in the United States, or like 48%. We have 1.2 billion people on Facebook. You know,
Well, I'll give you one data point of myself. Okay, I needed to get a new phone yesterday because my phone is like completely gone. Now I wanted to get the Motorola G4 because I'm cheap. Now I can buy it and get $50 off if I allow Amazon advertising.
Okay.
Okay, now I probably wouldn't mind the advertising, but I'm creeped out and I don't know what else I'm signing on to by having that. So in some sense, like I made a purchase decision based on the fact that I'm nervous about,
And I think
you know,
that-
having that, making that agreement. And, you know, so I think that maybe it's starting to affect people's.
No, what I'm saying is, I mean, that's the kind, first of all, I'd love to get that data because that's the kind of data that is revealed preference. You said
Right.
you're creeped out, and I'm not here to make a value judgment and say like privacy is valueless and we shouldn't care, right? It's just that, you know, if you look at where the evidence comes from, I mean, you know, as I said, you know, I am concerned. I worked at the FTC for 8 years. I'm a big fan of the agency. And I would think, you know, we're talking about FTC versus FCC. I firmly think the FTC's harm-based approach is the way to go. Okay, sort of,
Okay.
you know, there's, you know, it's more flexible,
Right.
and all that. But I think also to the extent, then, so you've got the problem though. The FCC sort of says we're going to import this FTC framework based on the distinction between sensitive and non-sensitive data. Now, I think they get it wrong going with the non-sensitive data, but to the extent they're importing the FTC framework, they're importing a lot of the problems that come along with that, where the policy positions or the framework are all based on, you know, workshops, based on, you know.
I'm just going to give Mark a chance to jump in here.
Well, can I just want to
sure.
finish one more thing. I mean, kind of my last thing here is that, so coming up, we're going to have the AT&T Time Warner, right? And so I think privacy analysis really needs to grow up. So when we think about the way that this merger, and I grew up as an antitrust attorney. I worked in antitrust and mergers and deals like that. So how's this deal going to be dealt with? Well, there are going to be economists, and they're going to be bringing complicated models of vertical integration and networked economy, right? So, or in networked industries on one side and then on the other. And then they're going to bring a host of empirical data that's already been done, and then their own data. And that's how we're going to figure out whether or not this merger goes, right? It's going to be a battle of very sophisticated economics. I have no idea how it's going to come out. It's going to be contentious, but that's how it's going to work. On the privacy side of things, we don't have anything close to that, yet it's just as important, right? We have transcripts of workshop testimonies. We have Pew surveys, okay?
Right.
But the thing is, in the real world, we have revealed preference, and we have this stack of studies that suggests, like, you know, like I said, the glass is half full. It's not half empty, but yet, you know, we're kind of running around like something really needs to be done, and I'm just not convinced that the market isn't in with the FTC and tort law in the background isn't mediating
People may say that
this.
they're concerned, but they're not showing that in terms of their, like, whether they're buying and the services that they use and the services.
That's the exact difference between revealed and stated preference, and why, you know, you're never going to publish it. You look in the peer-reviewed econ lit, you're not going to find a survey.
Right. Okay. All right. Mark, I'm going to let you jump in.
I want to jump in. I'm not an economist. I am married to one, so I feel like I'm an economist. But
That's
I want
close
to.
enough.
My wife probably feels the same way.
Yeah. But I do want to say, I mean, with respect to James, I think a lot of the classic economic models really break down with the internet economy. And this is something that's been, widely observed across the political spectrum. To begin with, most of the internet markets are two-sided markets. I mean, you have a consumer who's receiving a free service. In exchange for the data, you have a service provider who's taking that data and then selling it or engaging in a business relationship with an advertiser. And what I've just described is a very large part of the entire internet economy. This is not a relationship between a customer and a company where the customer says, oh, I don't like what this company's doing, I have lots of choice, I'll go elsewhere. I think if we had that style of economy for the internet, the need for regulation would obviously be different. But how many places are you guys going to go to do search on something on the internet? Where do you go for search? Where do you go for social networks? It's essentially monopoly or duopoly structure. And as to harm, I think the case has been very well made by the Federal Trade Commission. The FTC has reported now for almost 15 years that the number one concern of American consumers is identity theft. Now, what that comes from, of course, is the failure to protect personal information adequately so that it becomes available to criminals and others who misuse data. This isn't to say that I wouldn't like to see the use of market forces to bring, better outcomes. I think that can be very positive, particularly if we could encourage innovation. I mean, we're big believers in what we call privacy-enhancing techniques, which essentially would enable transactions in commerce and communications while minimizing the collection of personally identifiable data. But we need to see which providers can actually make those techniques robust and workable and which providers can't. And if it's possible for some market pressure to reward those who succeed, I think that would be a very good outcome.
Well, I also just want to kind of go back to this question of sensitive data versus non-sensitive data. And what does that mean? And, Baron, I don't know if you want to jump in, because I guess your argument might be we don't know what exactly that means because we haven't seen the proposal.
The FTC approach hinges, as James keeps saying, on harm, because unfairness is about weighing harm with benefit and asking about consumer empowerment. So if consumers aren't empowered, if they can't reasonably avoid something and it does more harm to them overall than it creates benefits, that's an unfair trade practice. The FTC has authority to go after it. Even if it doesn't create harm, if companies are deceptive about it, the FTC has authority to go after that. That's when we talk about the FTC approach, that's what we're talking about. Now, the question is, okay, so the FTC has developed a framework based on that. That's what I meant about the multiplication function. They've taken that approach, they've gotten some other inputs, some data, and they've come out with not only a distinction about sensitivity, but a distinction about context. I just want to read a sentence here that comes from the FTC's 2012 privacy report that I think will help provide context for our discussion, which is it says that companies do not need to provide choice before collecting and using consumer data for practices that are consistent with the context of the transaction or the company's relationship with the consumer. Now, what that means, and the FTC goes on in its report to expound upon that, is that the FTC was reluctant to draw rigid lines and instead wanted to keep its approach flexible so that in part they could agree with Mark sometimes and say that certain things were not appropriate given the context of the transaction. What the FCC appears to be doing is drawing exactly the kind of bright line that the FTC said it didn't want to draw, along the lines of the two categories of data in particular that Maggie mentioned, or maybe it was Kristen that mentioned at the outset, of web browsing history and app usage, right? They appear to be saying that regardless of context, we think those are just kinds of data that nobody should ever expect that would be shared, and then that should require this whole framework of opt-in approval and so on. Okay, so that I think is mostly what we're actually talking about. So in response to that, I would say, well, context actually does matter, and it matters in particular because people often misunderstand what's really going on here. So the example you gave about what sort of data is being used, people have this sense that their data is being sold to advertisers, right? And that might sometimes happen, but in many, if not most cases, what we're actually talking about is, and I'll just take Facebook as an example because it's easier to describe. What Facebook does if you want to be precise about it, is Facebook sells to advertisers the opportunity to find someone like you. That's a really important distinction. Now, you may not seem different to you as the end user. You may feel creeped out about it, but it is really different. It means, in particular, that Facebook is not transferring that data to third parties. Facebook is looking for characteristics that define you and then running their internal service such that when advertisers go to it, they can say, I want to show an ad to a white guy who lives in DC who likes Baroque music, which is me. For example, that's actually my license plate. So that's different, and you can see how that actually starts to change the way that you understand context. Because if the transaction were that your usage history, if every single website you were visiting, if that list was sold to a third party, I might feel very differently about that. So we need to parse these distinctions carefully. In my opinion, the FTC approach does that, and it would allow someone who's very concerned about their privacy to have an appropriate level of scrutiny when that was merited without overreacting. And then I'll let Mark jump in here, but I just want to say one more thing, because Mark mentioned the fact that there's a limited number of players who right now can offer search, right? Search is really important because search is the clearest expression of what people are interested in, and it's extremely valuable to advertisers. And what this debate in large part is about introducing competition into the advertising marketplace so that you have other aspects of behavior that can overall offer advertisers an opportunity to find people who are interested in a particular kind of product. And to me, that's an introduction of competition into the advertising marketplace that could, for example, allow new business models for providing service to consumers that might mean discounts on service, just as you got a discount on your phone. And we shouldn't take a restrictive approach to those. We should let those, or you chose not to, but you have a little more money than some people, and other people may choose, to James' point, they may choose to have a discount on their plan, and we should respect that sort of decision making, and we shouldn't assume in advance that these are bad for consumers.
Well, the one point I want to make, though, is in all of this, and correct me if I'm wrong, the FCC isn't saying that companies can't do that. They're just saying that consumers need to give consent to do it, right? So the difference here is that under an FTC model, it's happening, and me as a consumer, I never said that was okay. They're just doing it. Whereas under the FCC model, I as a consumer have to say, just like I had the decision of whether to buy that phone or not and accept that deal in advertising, that I was okay with that. So we're not saying that it can't be done, or the FCC isn't saying that it can't be done, right? I mean, so how important is that distinction of, giving the consumer more choice? And, there isn't an FCC person here, but if there were, I'm sure that would be their argument is, this is all about giving consumers choice. Why is that not a good thing? Mark, I don't know if you want to.
Well, to me, it's actually a very outdated concept of privacy to be talking about choice. And it's not because we don't recognize that people have wide-ranging privacy preferences. I mean, even the same person for different services or different periods of time has wide-ranging privacy preferences. But if you really want to be serious about choice, I mean, it's not only that you consent to disclosure, you also need the opportunity to withdraw consent. If you're not happy about the business practice, you need the opportunity to have your data deleted if you leave the service. This was a long-running battle we had with Facebook, for example. So I think the FCC's formulation of what the privacy interest is here is really, it's very slender. I guess that's the most generous thing I could say. But coming back to Barron's point, I think it was actually an important distinction you made. I mean, you're right, of course, that Facebook advertising is largely about targeting demographic groups, and you can get quite granular, but there is an argument that says it's not really the kind of privacy violation that goes across the line of personally identifiable information, and it's not the kind of privacy violation that involves transfer of personal data to third parties. I think, at least at the current time, both of those statements are true. But I guess my question to you, coming back to what's sensitive and what's not sensitive, if you're okay with this model, why would you not distinguish this model from the model that says, yes, but we can get access, to weblog data, we can get access to IP data, and we can use that very fine-grained individualized data for marketing purposes. Wouldn't that seem to cross the line that Facebook in your description otherwise respects?
Well, it depends, right? So what I'm arguing here for is really about the approach and not the particular outcome. So my answer is that we don't know exactly what's going to happen in the future, which is why the FTC itself said we shouldn't be drawing rigid lines and we should have a framework that gets us to the right answer in a particular case. So I might actually agree with you in a particular case. I'm simply saying I want the right questions to be asked, which is about context and about sensitivity of data, and that may lead us to agreement on particular things. So if, for example, if we're talking about a broadband company literally selling to a third party a list of the websites that I have visited, totally agree with you. That should clearly require opt-in consent. But there's a range of things that or a spectrum of options that can get lumped into when the media talks about this, or when the agency talks about it, or when the agency writes a rule, that can get lumped into that are well short of that. And I'm simply saying that the things that are short of that don't necessarily rise to that level and shouldn't require the same level of rigid consent. And if we do start applying that same rule to everything, we wind up with a really unlevel playing field that skews the advertising marketplace, that prevents the development of service plans that may help people for lower incomes who really don't care as much as some people think they should about whatever aspect we're talking about of, for example, like having an ad shown to you based on your web history is different from that web history being transferred in its entirety to a third party.
Maggie, can I jump in for a second?
Yeah, sure.
I think
You
we should
actually worked at
reorient.
Facebook, so you know a little more about this.
I did work at Facebook. I think we should reorient the audience here, though, because I think the problem with this conversation points out another major flaw with the FCC's rule as currently drafted. Again, I'm not opposed to regulation in the privacy space. I just don't think this is a good one, and I don't think it's well considered. And here's why. All of this discussion keeps boiling down to what we all know and we're comfortable with. This is discussing search and social media. This rule doesn't address any of that.
Right.
Instead, it suggests that the FCC will have new authority over privacy rules around when companies are acting as internet service providers. Not in terms of their being edge providers, when they're doing all the things that you see as a consumer, when you're surfing the web, all those websites. Not when you're doing social media. Those things are all still with the FTC. And so what I'm finding here, again, is another reason that I think this rule is flawed, because it doesn't meet the tech neutrality test. We have a whole series of technologies which are converging. We have a whole series of companies which are becoming vertically and horizontally integrated in ways that the '96 Telecom Act never could have considered. In fact, that rule imagines a siloed universe where phone companies are phone companies, internet companies, whatever they're going to be back in 1996, there really weren't so many of them, are going to be internet companies. And this idea of edge providers was really this really, really new thing. And now we have a rule which is being proposed by the FCC, which perpetuates this same idea that we can differentiate companies based on one type of technology, when in fact we have companies buying and selling and merging up and down, vertically and horizontally, and that changes radically the nature of the consumer to the companies they're interacting with. And frankly, the rules that are set forth here in the FCC don't recognize the very mergers that the same unit of government, the FCC, is going to have to opine upon shortly about whether or not there are mergers. That seems totally incongruous to me, and I'm not sure it has any real advantage to either consumers or innovators.
Right.
And that's a real problem.
So some people may know that we also do a lot of work on international privacy issues. And one thing that has struck me in this discussion is I guess the forward-looking nature of the European Union approach to privacy. When they adopted the Data Protection Directive in 1995, they basically said, listen, we're not going to try to draw these fine-grained distinctions between industries and sectors and services. We're basically going to say that if you're collecting and using personal data, you're going to have some obligations to protect privacy. Now, of course, there's more to it than that, but you see this approach, which has sometimes been described as an omnibus approach, avoids many of the problems we're talking about today. And if you can get out in front of a regulatory issue and say, as we tried to do, with the internet, we're not sure exactly how things are going to evolve, but we think there should be a common approach that's nice and simple and straightforward and not, 300 pages of regulation. I think everyone would prefer that. But here's the reality. You see, the U.S. went down a different pathway. We decided not to do the common approach. We had some sectoral legislation, we had some self-regulation, we had some agency rulemaking, and we're at this moment in time where the reality is there are not effective protections, privacy protections for the provision of ISP services. So what are you going to do? I mean, you're going to say, gee, unless we have a coherent, comprehensive approach, we're just going to leave that hole open, or you're going to say, well, given where we are, we need to come up with a solution. It's obviously imperfect, but I do think it's better than no solution. I think that's the key point.
Can I ask a really quick question? I know James and Kristen are dying to jump in, and I don't want to.
Right.
Mark, I just want to, the FTC has actually regulated at least 4 times the conduct of ISPs for privacy. Mm-hmm. And I just want to make sure, did you think those were inadequate in terms of their enforcement actions, that they weren't fulsome enough? I think that's a fair argument to make, but it wasn't the case that there was no privacy regulation over the conduct of ISPs, internet service providers, with respect to their consumer data and what they were doing with them. So I'm not finding the justification to shift jurisdiction from one agency to another, and I'm not going to go, wow, consumers have benefited because of this.
Right, but
I'm not saying that you are either, but
are you saying that the FTC currently has authority to regulate ISPs? I mean, that's not true.
I think it has been. I mean, the FTC is.
No, I'm not saying has been. I'm saying Are you arguing that the FTC could currently protect consumers?
Well, the Ninth Circuit says otherwise now. But
No, he's simply saying that the FTC did a good job when it had authority, and so now that the FCC has authority, which we all agree it legally has, that the FCC should look to the FTC's approach.
Right. And we could drill down a little bit. I'd have to think what those ISP orders were, but at least from the cases we've been involved with, and we had great hopes, by the way, for the FTC. I mean, you really do need to understand, we spent a lot of time. The U.S. doesn't have a privacy agency. We said, maybe we can make the FTC into that privacy agency. Maybe we can get some comprehensive rules for the major internet companies. If that had worked, we'd be having a different conversation. I don't think it worked.
But Mark left out the worst thing, which is that, because we didn't have comprehensive baseline privacy legislation, the tech world, all grew up in Brussels, and we all use European companies every day. I mean, look, the fact of the matter is that there are trade-offs here, and the fact that the United States took a sectoral approach, which was to say that Congress made judgments about particular things being particularly sensitive, like children's information, that was a good thing. It allowed the tech world to grow in the United States and to build the services that we know and love, with the Federal Trade Commission operating as the cop on the beat. And Mark, you may think that there are some things that the FTC should do more of. There are actually cases that I think the FTC should have brought. But in general, the FTC has been, in my opinion, a very, very aggressive privacy regulator, and if anything, has had too little constraint upon its discretion because it's managed to evade judicial scrutiny.
Okay.
But speaking as a former in-house privacy officer, we lived in fear of the FTC because you didn't know. I mean, you could look at guidance, you could look at the reports or the enforcement actions, but the entire privacy program is designed based on here's what the FTC has said, here's what how many times did my business people come to me and say, well, what is reasonable here? And you'd have to parse through that and figure out what is reasonable security. Is it best practices? Is it, what do we say? So I think that they do have a lot more power than you're giving them credit for, and influence. James?
Yeah, I mean, I just wanted to jump in and say first, I think maybe there's some agreement between Mark and me with respect to, there should be one set of rules would be great. I guess I just think that they shouldn't be rules. I kind of like a harm-based tort-like model, kind of like the FTC has, don't lie and don't do something that's on net harmful, and we can, disagree over whether the FTC's been effective. And one other thing, and I don't know if this is probably getting too far afield from the discussion, but one of the differences, I think, in the way that Europe sort of grew up and as opposed to us, I don't know to what extent the First Amendment has an issue with that too, right? So, I mean, the First Amendment has been, is there somewhat cabining privacy regulation, I mean, to the extent that privacy restricts the free flow of information, and at the same time that, it feeds into advertising. You just have the commercial speech doctrine, if not outright. Now, I know that, and I don't know if it's really a circuit split, but of course, with the CP&I rules in '96, there was U.S. West, and the 10th Circuit said that was unconstitutional, the opt-in. And then I think Epic, I think, was involved in.
We litigated we litigated both of those cases, actually. I remember them quite well. They were challenges to the FCC's rulemaking authority for CP&I, and in the U.S. West case, the 10th Circuit went with the telephone companies and said that there was an inadequate record to support the rule. The agency went back, rewrote the rule, and when the National Cable Telephone Association challenged in the D.C. Circuit, we did an amicus in that case, and the agency rule was upheld. But I actually thought the outcome was good in the sense that I do think agency rulemakings need to be well-founded. There needs to be evidence in support of an outcome. I don't think you want agencies just going off and doing, whatever they wish.
So I guess I just wonder to what extent could the First Amendment be a cabin here for what the FCC
but not under
is doing?
but this is important to your point. I mean, I think the D.C. Circuit answered that question in 2007 when it held up the agency rule or preserved the agency rule against the First Amendment challenge. So
I mean, I know we're not on agreement on, which approach is the best, but what should Congress be doing? Should Congress be doing something?
Yeah, well, yes. The FCC, let's just take a big step back here. Remember, this is all the result of the fact that the president, after getting shellacked in the midterm elections in 2014, came out and ordered the FCC to change its approach on privacy. Right? The fact that the FCC used not just Title II, but the most fulsome version of Title II is what started us down this road. It is just one unintended consequence of that. And that is something that could be fixed by Congress. And the number one thing that Congress could do about this is the reason that the FCC now has to do something, the reason there's a vacuum, is because the FTC's jurisdiction is general except for common carriers regulated by another agency. So that common carrier exemption is something that Democrats and Republicans have for a long time agreed should be ended. Contrary to what David said in his introduction here, when he suggested that people were trying to take away the FTC's tools to protect consumers. Actually, many of us who've criticized the FTC have said we should end the common carrier exemption, just as we should end the exemption over nonprofits. So if anything, I want to see the FTC have more general jurisdiction, to Mark's point about comprehensiveness. I agree with that. I would say fix that, stop the FCC from regulating here, because I don't think it's necessary to do that once you restore the FTC's jurisdiction, and then deal with the concerns that we and others have raised about the FTC having too unconstrained discretion, which would not really hamstring them. They'd still be quite a powerful agency. They'd still be able to wield a great deal of influence in the way that Kristen mentioned. When companies decide what they're doing, they have to think really hard about what the agency might go after them for. Nothing that any of us are suggesting is going to do that. We're suggesting really small tweaks to the FTC's enforcement approach that would simply make it more likely that the agency goes to court. They'd frankly still win overwhelmingly. But that would be the number one thing that Congress ought to do. And if I were running things, I would do that as part of an overall rewrite of the Communications Act, where we start really rethinking these lines that were drawn in 1996, when no one was imagining in 96 that the FCC would end up regulating so broadly here. And just one small thing, Mark mentioned that Maggie said something like, well, the FCC doesn't have jurisdiction over edge companies, and Mark said, well, not clear. Well, he's right, actually, because the FCC has also interpreted Section 706 to allow it to do anything that it asserts will promote broadband deployment. And people have assumed, many people, that that's only with respect to broadband companies. But that's not the FCC's interpretation. Their interpretation would extend to any form of communications, which is in part why I think it's an insane interpretation and can't possibly be right. And the court, I think, eventually will say so. But in the interim, Mark's right. The FCC could use 706 to regulate privacy and cybersecurity, and they have actually hinted that they will do that, which is a warning here, and it might be why companies like Google, we haven't mentioned this, you might think that Google would want to restrict any attempt to compete with them and thus be pushing for aggressive FCC privacy regulation, but in fact, Google and others have actually come in and said they support the FTC approach, and I think in part they're doing that because they understand that what begins as regulating the data collection practices of broadband companies will extend to other players in the ecosystem if for this reason or because of some of the other ways the agency has interpreted its authority could end up leading to regulation of edge providers and could end up creating a more European-like approach to privacy and data security regulation across the board, which I think would be a disaster for the entire tech sector.
Tim, I don't know if you wanted to jump in with what you think Congress should be doing.
Yeah, I do. Thank you, Maggie. There's two things, at least, that Congress should be doing. And let me step back for 1 second. The next quarter century, for all of us, the whole marketplace here, irrespective of what type of technology we're talking about, is all a competition over data. It's all a competition over data, and in particular, consumer data. And anything that either a regulatory agency does or Congress does that affects that competition is going to have a really profound set of consequences, maybe benefits, but certainly consequences for consumers, their choices, for small companies who want to start and do great new things like many of the CALinnovates members, and for big companies and their position vis-a-vis other competitors. So there's two things that I think Congress needs to do, understanding that it's all a competition over data. One, I said this before, and Barron said it, I think, for different reasons, but the 96 Telecom Act does not make any sense whatsoever anymore. It is written industry by industry, technology by technology, and that world just doesn't exist anymore. Witness again AT&T's announcement that they're buying Time Warner. That's just one in a series of mergers we've seen across sectors, across types of companies, and that's all about data, right? It's an attempt to compete with other companies out there which AT&T or Verizon believe already have a large amount of data about consumers. We should rewrite that and we should make it tech neutral. And if we do that, we're going to end up with lots of better rules on a lot of different things and probably a lot less market distortion. And certainly, I think, ultimately better privacy outcomes for consumers. And the second thing is I think Congress has got to keep a really clear eye on the signal we're sending to Europe. And in particular, over this agreement known as Privacy Shield. Privacy Shield is the renegotiated safe harbor that allows companies to gather information from European consumers, bring it to the United States as if it was a physical good, do all sorts of things for it, and send it back to Europe, or to do things on behalf of Europeans. That Privacy Shield agreement is central to how most of the world's multinational corporations think about their behavior with respect to data. The Europeans create a great constraint on corporate behavior, especially about consumer data. And one of the things that the Europeans have said is in order for those agreements to stay in place, for a cross-border data transfer to occur, there has to be one privacy regulator that's more important than all the others in the United States government. And one of the unconsidered consequences of having the FCC take this jurisdiction is it vastly diminishes the FTC's ability to be, as Mark, I think, rightly championed over more than a decade, the privacy cop here in the United States. And I don't know what the effect is going to be, but it's going to be profound. And it could end up in another one of these clincher moments where we have like an eyeball-to-eyeball negotiation over what's going to happen and whether American companies primarily can access European consumers' data, usually because the European consumer wants them to do things for the Europeans and send the data back and forth. And that's really weird, and Congress has got to at least keep an eye on it.
Kristen, I don't know, do you have anything to add in terms of what you would like to see Congress doing?
No, I was going to mention the Privacy Shield agreement because, it clearly designates the FTC as the enforcer of that agreement, and I think DOT actually to some extent too, but the FCC is nowhere in there. So what happens to that still remains a question. And then the common carrier exemption, of course.
Yeah.
So.
How about you, Mark? You want to?
Well, just a couple of quick points. I mean, I'm glad that Tim raised the Privacy Shield. It's actually my view that if the FTC does not act in the WhatsApp, Facebook matter, I think it will simply collapse. Because the FTC is such a critical backstop in ensuring confidence in the U.S. approach to privacy protection, which I know several people on this panel have said is preferable to the FCC approach. I think the litmus test for the FTC will simply be the Facebook WhatsApp matter, and I think on that basis, Privacy Shield continues or it doesn't. Now, to answer your question, Maggie, as to what I would like to see happen in the next Congress, again, I'm not going to back off on my view that I think we need much stronger privacy protection in the United States than we have currently. I think it's important not only for consumers, I think it's important for the long-term stability of the internet economy. I think businesses should be concerned about diminishing public trust in internet-based transactions. That can't be a good thing. So I think we need much stronger protection. I think to the extent that it has a minimal regulatory burden, that it's coherent and effective, obviously these are key goals. What we had proposed some time ago was a framework, a statutory framework for privacy protection. We might even be able to recapture some of the FCC authority and some of the FTC authority and harmonize that in the context of a federal statute that's a baseline. And I think you need a privacy agency in the U.S. precisely because there is too much confusion between multiple agencies working on these issues. And if you want an analogy in the not too distant past about how this can come about, post 9/11, we created this new federal agency, the Department of Homeland Security. I'm not here to say it's good or bad. I am here to say that it was possible in response to a very big national challenge to rethink across the federal government a lot of legislative authority, a lot of committee oversight. I actually think the moment has come now in the U.S. to do that for data protection.
Okay, James, and
Yeah.
then we're going to open it up to questions.
Oh, okay, yeah, I just thought I'd echo, I think getting rid of I've said this a lot when I was at the FTC, that was always has been the position of the FTC, get rid of the common carrier exemption, and I think that would solve all these problems. Get rid of the common carrier exemption, they can operate under an MOU like they did before, or even fix it so the FCC has no privacy jurisdiction. I don't know how Congress works. I don't know if that's easy or hard. So you guys tell me. I just sit back and write papers that no one reads.
It's really easy. It's a no-brainer.
Yeah.
Just snap your fingers, it gets done. Yeah.
The one thing I'd say, I wanted to respond to Mark, or at least talk about, he talked about the Facebook WhatsApp merger is kind of the litmus test, or not what they're going to do is going to be the litmus test for Privacy Shield, and I hope that's not the case. I mean, I could see that that happening, but to me that brings into sharp relief what what I've been talking about, what I keep beating, just the chasm in analysis. I mean, so, you've got Facebook and WhatsApp merged. They go through this really sophisticated analysis called the Horizontal Merger Guidelines, FTC, you got economists doing this. And then, okay, now we got data and we want to put it together. So what do you end up with? You end up with a letter from the Director of the Bureau of Competition, Consumer Protection that cites 2 consent agreements. Neither one have to do with they just have to do with lack of notice. They're consent agreements. They don't have to do with the type of choice. But from that rule,
Privacy settings.
there are no. It's Golden Shores and Facebook changes in privacy settings, but not telling anyone. Here, it's clearly being told, and these are being cited to say, well, if you're going to merge the data, you need express opt-in consent for everyone. And so it comes out of a letter that comes out of 2 consent decrees and some workshop reports, which are really just a collection of tables like these, and we take transcripts. Really, I mean, we're smart people, or many of us are, not me, but the rest of you guys are smart, and we collect this and we write. Could you imagine blocking the AT&T merger based on a panel of transcripts. Some smart people sat around and said this would be a bad idea. But this shows to me, just the chasm. But
This shows that James doesn't work at the FCC, because that is actually how those mergers get blocked. But
well, okay. At the all I can say is the Department of Justice. I mean, but to me, the Facebook, WhatsApp. I mean, it's a litmus test, perhaps for Privacy Shield, and that may be the case. And I think, Mark, you bring a compelling political point there that may be. But I think, to me, it's a litmus test. I would like to see the FTC say, look, we're going to look at, where, to me, this is like, where does this opt-in consent requirement come from? It's kind of just comes out of thin air. Like, if you're going to merge data, you need express opt-in consent. If you go back and look at where it comes from, there's a blog posting from an FTC staffer, and there's, a letter. And that's it, right? And so that's how we're making up. And to Tim's point, this is really, really, really crucial, right? This isn't just, some sort of academic exercise. There are real consequences to how data is merged. And should we come up with these rules just out of thin air based on, hey, express opt-in consent sounds like the right thing to do. We got a panel of some smart people that say, let's do it, right?
Okay, all right, I'm going to take just want to get to some questions before we run out of time. Right here.
Carl Zimmer, that choice, James is going to hate me, then love me in a sec. It's going to hate me because the Pew study that was cited earlier actually says people trust government less than they trust advertisers. So maybe that Pew study shouldn't be used to justify government action. It's going to love me because action for Congress maybe should be to fund the type of harms-based analysis study, cost-benefit analysis study of the privacy implications that you're talking about.
There's actually a donate button on our website, so if anyone is really interested in funding, then that's what we do. We fund research, so yes. Thank you for the plug.
And one of the things that I teach my students is cost-benefit analysis as well. And Baron, because you put this panel together, and it's got one of the questions is the reclassification of sensitive information. Can you talk about perhaps some of the harms of the reclassification?
Yeah, well, so one of the things we don't know about this is exactly what is going to be in the FCC rule. I mentioned at the outset. So it's reasonable to assume that the FCC is going to treat all IP addresses as sensitive information. So it won't just be the list of your browsing history or your app usage. It would be that as well. Now, that sounds great to most people, but we've already seen one clear example of where that's had some negative unintended consequences, which was the FTC's expansion of the COPPA rule, which ended up really limiting what kids' sites could do, because in order to deliver videos, have an embed from YouTube, that is going to involve the collection of personal information. So sometimes I fail to distill this into terms that people can actually think through. So what we could actually be talking about a situation where if a broadband provider wants to start displaying video content along with its offerings, they may end up having to get, in exactly the same way that some edge provider does today, they may be subject to an opt-in requirement where some edge provider would not. And to me, that starts to skew the playing field, and it starts to chill the development of services that are probably what people have in mind when big content providers merge with big distributors. And I don't think the government should, in advance, be chilling that sort of change in industry.
But I also think, if I could just add, when you're talking about harms and sensitive information, in addition to the contextual considerations that Baron read from the FTC report, there was this consensus, right, about what is going to cause the most harm to consumers, and that most sensitive information was going to be opt-in. So it's the categories that they had in their report, and then yes, contents of communications, and thinking about contents of a point-to-point communication that I think is private, not the internet ecosystem where on one website there are multiple parties that have access to this information. So that type of information, I think, inherently can be sensitive. Whereas you have other information that privacy is very subjective, and what concerns me, and I've had this conversation with my children, clearly doesn't concern my children. And then, my niece who is now looking for a job just changed her Facebook name so that her future employers can't identify who she is. So she's caring about privacy in a different way now. And I think that changes over time and person by person. So your web browsing history, your app usage, the idea that I wouldn't give consent on all of it is not right. It's just whether I'm going to choose to opt out of that consent based on my personal preferences. And I think having a clear notice where I know what choices are available to me is very important.
Okay, I think I saw another hand back here. Did someone else? Okay, go ahead.
So I just wanted to return to something early on. I think I heard Mark say that, for the FCC, that we'll do this first and then maybe we'll get to the providers. Is that accurate?
I don't think I said that. Sorry. I think I said that there was a view in the privacy community that we would get first to the ISPs and then to the edge providers, largely with the goal of having a harmonized approach. The letter that Epic wrote to Chairman Wheeler at the outset actually urged a harmonized approach, and we even made note of the fact, I mean, you may not like the European approach to privacy protection. I think it's had some benefits, but remarkably, Europe is going through this exact same process. They're updating their communication privacy laws, and we said the FCC should be aware of that and see if we can get a harmonized approach for the fairly obvious reason that the internet is a platform for a global economy. And Privacy Shield came about in part because there was such divergence between these two approaches. So again, if you're thinking over the long term and how you maintain and grow a stable platform for economic transactions, I think it's in everyone's interest to do that. The reality is that it just may take several steps to get there.
Let me just clarify. Mark wasn't saying anything in particular about what the FCC should do. He was simply noting or alluding, perhaps, to the fact that the FCC has implied that its authority might be broader. I would direct you to, for example, the 2014 inquiry about the state of broadband deployment, the 706B inquiry. That was at least one example, and there I think have been others, where the agency has asked they said, oh, well, among other things that could promote broadband deployment, what about concerns about privacy and data security? And to me, that says very clearly the agency is building a record. The other shoe has yet to drop. They haven't yet actually said that they're going to do privacy regulation based on 706, but it's only a matter of time. And you have to look at what the agency has done with the authority it's claimed. And what we've seen under this chairman is he's been willing to break all limits on the agency's authority unless we get a radically different chairman in the future who maybe is a lawyer and cares about legal details. You should expect that to continue. And what that means is the agency is going to look for new and creative ways to push its authority, and they'll do it case by case or in a rulemaking. So I really stand by my statement that what is being done here today for broadband providers is simply a roadmap in the future for what happens to other internet companies. And again, Google's concern about this suggests that my supposition may be correct.
Well, okay, one more question, go ahead.
Oh yeah, Katie McCall of Americans for Tax Reform. Thank you guys so much for going through all of this today. I was wondering, just in the context of opt-in versus opt-out, like currently if I'm on my phone and there's an app and it says, hey, we want to access this, and I'm like, no, I don't actually want you to. They're like, okay, you can't have the app. But so in the FCC rules, I'm under the impression that if a customer wants to not provide that particular information, the ISP cannot deny some type of service. So I'm wondering if this is precedent setting, what that does to on-demand services, or say the mobile economy that's already opt-out, and kind of how this transitions forward.
Okay, and before we get to that question, I'm just going to say it for the mic, and correct me if I'm wrong here. So your question is about this opt-in, opt-out, if it's precedent setting in terms of the way the rules, and I understand, I think the way you do read, it seems as though if you say you're going to opt out, they can't deny you access to an app. Okay.
No, I think that's the, sort of the take it or leave it part, right? That you can't do that. And I think that in, maybe you can make an argument that in monopoly areas with, in the hardwired broadband, that perhaps that makes sense. But in the mobile area, I find that harder when you've got 4, 5, 6. You know, if I want to say, I mean, and that's actually in the FTC's, I think it's in the, you know, one of the reports, big data, Internet of Things, whatever, but they, 2012 report that, look, take it or leave it offers are, we may not like them, but if there's sufficient competition, then we shouldn't worry about them, because you know that's heterogeneous preferences. That's how we can sort, and you can say, look, you know, so in the mobile area. I can't imagine a mobile provider doing a take it or leave it offer, but you know, if they wanted to, and then this kind of goes to the other thing we talked about, not so much the take it or leave it, but discount for, you know, discount for your service. You know, Sprint gives you a discount if you're tracked, or AT&T, or whatever, and those will be disfavored again in a highly. I don't think anyone would say the mobile broadband area is not highly competitive, and you know, just look on the or NTIA website, the map of, you know, most people have 5 or 6 people they can choose from. So, so anyway, those are my thoughts. I think it should be driven by competition.
And I think, you know, some of the apps actually require location to work as well. So there are some, I mean, there's that reason too why it might be, you know, subject to your consent.
That's a really good, I mean, the functionality point's really good.
Right.
Like, well, if you won't let us use your location, it's not gonna, it's like.
The app won't work, right.
Your bike tracker or your running tracker. You don't use GPS, well, I can't really do much for you.
It's not exactly precedent setting, but it's a little bit unusual. There are a whole series of state student privacy laws and student ed tech laws which have been enacted in the last several years around the country at the state level, which prevent this sort of take it or leave it opportunity. I think they sort of rest on the notion that when a company is in a position where most consumers have to go through a funnel, or they may go through a funnel, right, to get a service that the policymakers have agreed is important enough, that there can't be this kind of take it or leave it moment where people are forced to choose between privacy and the access to the service. So it's not completely precedent setting, but I think it's a new thing to have happen at the federal level here in Washington.
Right. And as we wrap up here, because we've only got a few minutes left, because we want to give you guys time to get to your next thing, you know, I guess I want you guys to sort of look into your crystal balls a little bit here. And one, do you think this vote's going to happen on Thursday? Because we had, you know, it seems like there's still a lot of controversy over this. The FCC pulled the set-top box item from the last meeting, and Barron kind of alluded to that. And also, we've got a chairman who's running out of time. You know, we've got an election coming up, and, you know, how much of this do you think this agenda is going to be pushed into possibly the next FCC? And I know that depends a lot on the election, but I don't know if anybody wants to.
I have no doubt that Chairman Wheeler will do everything he can to get this thing voted on, even if that means going and beating on the door of the other commissioners who might be trying to craft some sort of compromise, which has happened before. But that doesn't really answer the full question, because everything he does in these last few months is going to be subject to challenge in court. And it is certainly possible that this rule could fail and that we will be back where we started, doing this over again. But in my crystal ball, in the long term, I would just close by saying that it's a mistake to look at something like this under the broadband and internet ecosystem as it exists today. The whole point here is we're talking about rules that will be with us for decades, and we don't know how the broadband world is going to evolve. We don't know how video delivery is going to evolve, but cable itself, that is to say linear video programming distribution, is going to fundamentally change. That's why, for example, AT&T is buying Time Warner. That's why Comcast bought NBC. And if you look in the future and you start thinking about how those companies distribute video and how they interact with consumers, you can imagine all sorts of fact patterns where these rules today, as they're written, which may seem relatively uncontroversial, could really start to create problems for them and skew the marketplace in the future. And that's again why I would just refer everybody back to what the Federal Trade Commission said in its 2012 privacy report about how it was trying to avoid drawing rigid lines and was trying to instead have a flexible standard that focused, one, on sensitivity, and two, on context, so that it could protect consumers where there was a real problem, but it wasn't being pushed into drawing the kind of rigid lines that the 96 Act drew and that the FCC is now perpetuating.
Yeah. Anybody else want to
I guess
Predictions?
I don't really have, well, I worked at the FTC. I have no clue what, as you can tell, I don't know Congress does. I don't know what I know the FCC and yeah, exactly. A lot of people may be asking that right now, want their money back. So, no, I mean, I just think that, again, to echo, just sort of closing, or my closing here, echo what Tim said is, the stakes are really, really high. And I think kind of the FTC harms-based approach is where we talk about going in the future. The future's certainly unpredictable, especially in this fast-moving industry. We have no idea where things are going to be 5 years from now, 10 years from now. And I think that's a strong recommendation against rigid ex-ante rulemaking and for an FTC-based approach.
I just wanted to say, oh, sorry. Well, I don't know what the outcome will be. I do have a hope that, the final rule will address some of the concerns that Tim and Barron and others have raised about just the complexity, the sensitive, non-sensitive distinction. I don't think it's helpful on either side. I think carving out de-identified data, I don't see the value there. Even the pay for privacy provision creates some problems as well, both for customers and for service providers. So to the extent that it's possible to have a simple, straightforward, modest proposal go forward, I think that would be the best outcome at this point.
I think that this, a simple model would be great, but this is such a complicated area. And I think all of us, to some extent, agree that, there should be privacy regulations and that the FCC does, that has created this gap. And so it would be great if there could be a compromise. I think that would get them closer to the FTC and at least provide that consistency. But I think that, I guess I would predict that the vote goes forward on Thursday.
With no compromise?
One way or the other. I'm not going to go that far. I don't have that good of a crystal ball.
It'll be dressed up. What the chairman has put out has been dressed up as a compromise, but again, it really only briefly takes part of what the FTC has done. It still lacks that discussion of context.
So my glass half full hope is that it is a true compromise effort, but I think it goes forward either way.
Okay, Tim?
I'm going to resist making any predictions about what's going to happen at the FCC. I will predict that win, lose, or draw, however the vote comes out, whenever it happens, we're going to be doing this for a long time. Many of the flaws of our current system, I think, are going to be perpetuated by this model if, in fact, it comes into being through any kind of vote in the future. And I think we're going to be relitigating, adjudicating, reconsidering all of these questions for some period of time. I will say one other thing on behalf of innovators everywhere. When I agreed to do work with CALinnovates, I said we were never going to do an event without really killer cupcakes. So before you leave, I want there to be a competition not only over data, but over the cupcakes before you leave, because they're produced by another great innovator here in town. And I think everybody should avail themselves of a little innovation once in a while.
Great. That sounds
All right,
like a good place.
well, thank you all for joining us.
Thanks.
Yeah, thank you. I hope this was okay. And it's like...